This entry into the history of financial futures is sponsored by Eurex.
We were the regular outside counsel to the Chicago Board of Trade at that time. And I was a litigation lawyer. And the Board of Trade historically hadn't had a lot of litigation, but in the late 70s, it developed one case that went to the Supreme Court that had to do with the jurisdiction of the Commodity Exchange Act. And then immediately thereafter, you had the Hunt brothers' manipulation of the silver market. And that spawned numerous lawsuits because the Chicago Board of Trade had a silver contract. COMEX's was larger, but the Board of Trade had an active silver contract. So all of a sudden, we had active litigation around the country in 15 or 16 major jurisdictions. So I became intimately involved with the institution at that point in time because I was the one who was primarily defending those lawsuits. And that coincided with the development of the institution as a national and international financial institution because you had the growth of the Treasury bond contract and the related financial contracts at the same time. So right at the time when the exchange was moving from one platform into a whole different role in terms of the economy and in terms of legal regulatory status, I was catching the tailwind and riding right along with them in that regard until I became general counsel in 1983. Well, if you went back in time, obviously all of the principal futures contracts were agricultural. And so from a regulatory standpoint, the first thing is that self-regulation meant something more. The concept of an SRO, a self-regulatory institution, really meant something. 90% of the business that mattered was taken care of in-house and on the spot. But with the advent of financial futures, you suddenly became a much larger marketplace, a world marketplace, and the focus changed. And so consequently, you now had to deal with a great deal more on a regulatory standpoint, not just from the federal level, but from the related markets as well. So the government sees this, and previously for 100 years, you'd had the federal oversight of the Chicago Board of Trade and the CME being a division of the Department of Agriculture because they were primarily agricultural contracts. With the birth of financial instruments and the breadth of investment that comes into the financial markets, the Congress saw fit to create a separate agency, the Commodity Futures Trading Commission. And in 1975, that was finally done, and that was born. And that created a whole different level of regulation that previously really hadn't existed. I had been outside litigation to the counsel to the Board of Trade during this period where for the first time they really had some outside litigation to handle. So I was very familiar with the management and the directors and the board of the Board of Trade. But then there was a shift at the Board of Trade in that regard, and a shift for me as well. I had left and gone and opened my own law firm. And I got a call one day to say that I was being interviewed to be the general counsel of the Chicago Board of Trade. And on the one hand, I was very happy with what I was doing, but on the other hand, I hadn't met anybody in this new regime down there. So I went down and figured that worst that could happen was I'd make some new acquaintances. And I met Tom Donovan, who was the new president and the new executive committee and the board. And one thing led to another very quickly. And so I had to make a decision as to whether or not I enjoyed my current job more than the challenge of this new position. And the challenge of the new position was, to me, irresistible because the institution and the industry were taking a huge leap in a very different direction. It was a growth period, and it was the chance to be there on the ground floor. They're two very different people, two very talented people. Bob Wilmouth was a banker by background and a very talented and very disciplined man, but used to being a banker, which was a classic downward management CEO kind of mentality. Tom Donovan came from an environment where you had to manage an enormous number of different interests, having been Mayor Daley's chief of staff for so many years. And the Board of Trade as an institution was much more akin to the city of Chicago. It was much more of a Greek state than a typical corporation. And so you had this concept where all of the members constantly had opinions, and there was a huge political process that had to be done in order to get anything done as an institution. And so Tom was uniquely suited to be that individual, to lead that institution into that new era. And I think history proved that to be the case. He was a uniquely talented individual, and he had enormous integrity, and the Board of Trade respected both of those. As you developed into the 80s and the financial markets took off, and they really became part of the world economy, not just the national economy, you suddenly are in the spotlight of Washington, not just from a regulatory standpoint, but from a legislative standpoint. Things were being done in Congress. Because what happens when you have a newcomer come into an established institution, an established business in some way, you're goring somebody's ox financially. And they're going to take whatever measures they can to remedy that, and oftentimes it was national legislation. So the Chicago Exchanges very wisely recognized that they had a common interest in that regard. And so the Merck and the Board of Trade always worked very closely together. And Leo Malamed and Tom Donovan were a wonderful pair because they were both very politically astute. They both had long-range vision for what was necessary for the institutions. And Tom, having the experience that he had politically, was able to mobilize the forces which were necessary to deal with the political environment, which now was overlaying the regulatory environment that we had grown into. And so we developed into the 80s, not just as institutions that responded to our own regulations, SROs, federal regulation from the CFTC or the SEC or both at times, or even the Fed, but also politically in terms of Congress and legislation. And so you added yet another layer of legal and regulatory and political activity. We were fortunate in Illinois in the 80s to have some very influential representatives in Congress. And that's always your first layer. You go to the people who are your immediate representatives. And Dan Rostenkowski, as chairman of the House Ways and Means Committee, was very influential and very helpful and very loyal to his Chicago constituents. You had a number of others over the years who developed the same way. But what the Board of Trade and the Merck did in their political activities in Washington was recognize that they had to be broader than just Illinois and just the Illinois delegation. And so consequently, we established a program whereby we would look at the elections all the time and try and spot the newcomers who we thought were going to be power brokers and influential going on down the road. So, for example, we got involved with George Mitchell and Bill Bradley and a number of other figures early on in their careers, so that when the time came when we need to go to them and ask them to listen to us and listen to our side of a dispute that was going to be in front of them, the door would be open. And that was the key to it. I mean, I think people have a tendency to think, oh, you're paying big money out of a PAC to so-and-so and whatever, and that's why you got what you want. It was not the way it worked. The way it worked is that we supported people who we thought would be helpful to us in the long run, who would be influential, who would be successful in Congress. And when the time came when we needed their ear, they were perfectly willing to listen to us. Didn't mean they'd do what we want, but we had the opportunity to be listened to. The dispute over utilizing the Dow Jones as the name for the major stock index contract that the Board of Trade wanted to trade was a classic example of the New York versus Chicago kind of relationship. I mean, New York tended to resent the fact that Chicago was this upstart in the financial industry. They weren't part of the same cabal of people, didn't work together. And so consequently, when we came up and said, well, we're going to trade the Dow Jones, and Dow Jones said, no, that's our proprietary name, and you're not us, and we don't want you. Now you had to go to saying, okay, if it can't be done by cooperation, can it be done legally? And so the Board of Trade got a legal opinion, and it was not a close case, but they got an opinion that said, we think you can do this under these circumstances. So they went ahead with it, and it turned out that, as I recall, it was a 5-4 Illinois Supreme Court decision in the final analysis. I mean, it was a very close legal issue. But that took the cachet of the name off the contract, and we went to major market index. Some people say that was deleterious to the contract's success. Personally, I don't believe so. I don't think it was. I think in the final analysis, if you move forward back into the late 80s when there was a market turbulence and the New York Stock Exchange was shut down temporarily, we made the decision to open the major market index when no other financial markets were open. And as a consequence, we opened the contract, and the contract went up and was bullish, which the Fed and everyone was very thankful for, because really what the market needed at that point was a vote of confidence. And this contract that theoretically was not all that influential in terms of volume or whatever, at a critical point in time turned out to be extremely influential. The biggest issue was margins. If you'll recall, there was, again, in the late 80s, I'm forgetting the exact date, but there was a perturbation in the markets on the New York Stock Exchange, and the then president of the New York Stock Exchange, Mr. Phelan, pointed his finger at Chicago and said, "It's those futures markets that are the problem. It's not us. Leave us alone. We're okay." And it's the fact that they have 2% margins and we have 50% margins. Well, of course, margins in the security industry were a totally different thing than margins in the futures industry on an economic basis. Margins in the securities industry were in essence a loan. Futures margins were a security deposit that were adjusted daily, eventually twice daily. And two very different things serving very economic functions, but they had the same name, and it grabbed congressional attention. So we literally spent 2 years in Washington digging out from under the rock to prevent what would have been very deleterious legislation in Congress to changing margins by federal regulation. Anybody who has traded contracts will tell you, if you're talking about futures, the major attraction of futures is they serve this wonderful purpose and they're cheap. And if you suddenly start saddling them with all these extra regulatory costs, they're going to lose their economic appeal and you're going to drive them right out of existence. I think the sting operation garnered more headlines. There's no question. And that was a function of the fact that we had a member firm who was not happy with the fact that we had fined them. And so they went to their regulators and said, the federal government, and said, "You've got to come in and you've got to investigate. There's all these crooks and everybody on the floors." When that announcement came out, and it took us totally by surprise, despite wiretaps, moles on the floor as trading clerks and all the other investigatory powers they had no trader under indictment that we didn't already have under investigation. And quite frankly, I took that as a affirmation of the ability of self-regulatory functions. It was September of 1984, and the clearinghouse at the Board of Trade was a separate entity. There was overlapping directorate and overlapping membership. But it was separate from the exchange, and it had always been run separately, and the theory was there may be politics that go on at the exchange, but clearing is too important to have politics, so it's separate and it's sacred. So it was separate, and all of a sudden we woke up and realized that unbeknownst to really anybody, including the board of the Clearing Corporation, the officers had established a political action committee and had done it incorrectly. So they were being indicted and subjecting the corporation to being indicted. And so I went up on an emergency basis from position of general counsel of the exchange and simultaneously became the chief executive officer and general counsel of the Clearing Corporation. And fortunately, it was a tribute to the fact that the institution was so well established that I almost couldn't screw it up. And so when you made a margin call in the morning and said $20 million, what bank do you want us to draw it from in the next 59 minutes? Member firms understood that you paid the $20 million and you had questions later. And that's what kept the system sacrosanct, and that's what made it work. And we kept that going until the new CEO was established late in December of that year. And then I advised the board that I thought they needed a general counsel full-time at the Clearing Corporation in-house, which they hadn't had. And so we brought in a new general counsel at that level. But it was a time when a lot of individual members were concerned, and rightfully so, because clearing was an extremely important part of the industry, and for any perturbation and disturbance at the clearing level was going to cause a lot of unrest on the floor. Fortunately, people had a lot of faith in us and things went very smoothly, and so it almost went unnoticed by most of the industry. In the futures industry, it was not just an accounting function, it was a regulatory function, it was a risk management function, because you did start with relatively low margins on an initial position, but as your position varied in value, you were assessed additional margin or you got paid additional margin. In other words, cash flowed on a daily basis back and forth between the traders. And that helped keep liquidity in the markets amongst all the traders. And once people who had been used to trading a very different marketplace, where it didn't have that facility, really understood what function clearing performed in the futures industry, I think that helped the futures industry really boom, certainly internationally. Certainly when you had people from countries who had very little economic stability in their system came and said, you mean to tell me that if I'm right on my position, that I'm actually going to get paid at 4 o'clock every day? The value of how the position has accrued? They were amazed at that. And once the industry worldwide became acquainted with how really clearing had functioned for many, many decades at the Board of Trade, I believe it really gave a spur to the growth of the markets.